In this part 24, as far as our lecture series is concerned, we intend to discuss chapter 8 of the Criminal Procedure Code, which deals with security for keeping the peace and for good behavior. This is a time for me to draw your attention to make it clear that though during course of our introduction we have learned Criminal Procedure Code is a procedural law that tells you the mechanism to implement the provisions of the substantive law. Yes, very correct, no doubt about it. But at the same time, if you refer to chapter with which we intend to have our discussion today, you will realize that this is a preventive measure, and hence this is a time for me to make it clear that during course of time we shall, as we go on learning the provisions of the Criminal Procedure Code, you will understand that though we say Criminal Procedure Code is a procedural law, there are some chapters or some provisions in the Criminal Procedure Code which are substantive or which are preventive in their nature. This is one chapter. This is a preventive measure. Before somebody does a wrong or commits an offense, the court has got power to call him and tell him that don't do it, otherwise mind well the natural and probable consequences of the act. As it is rightly understood by everybody, prevention is always better than cure. So this is a preventive measure with which we shall be dealing right from 106 up to section 124 of the Criminal Procedure Code. If I may be allowed to draw your attention to right from section 149 up to section 153, this is also the preventive measure, namely preventive action that is taken by the police. Generally, we are under impression that police will come into picture only after commission of an act which amounts to an offense. But if you read section 149 to be read with section 151, you will understand the importance of the preventive measure. Police, they have got power to prevent the commission of a cognizable offences, and for the purpose of preventing commission of cognizable offences, the police officer has got authority to arrest a person even though he has not committed an offense as per the provisions of the law. When we shall be dealing right from section 129 up to section 148 of the Criminal Procedure Code, namely the chapter dealing with maintenance of public order and tranquility. This chapter we shall classify under different heads. 1. Dispersal of an unlawful assembly, where we shall be dealing right from section 129 up to section 132. There is a potential danger when 5 or more persons assemble together with any one of the 5 objects which are enumerated as far as section 141 of the Indian Penal Code is concerned. And hence, how to prevent that unlawful assembly in order to avoid the further consequences which are likely to take place is dealt by this part. Whereas, when we start right from section 133 up to 143 of the Criminal Procedure Code, this is a part of the chapter dealing with the removal of a public nuisance. And then, if we read section 144A of the Criminal Procedure Code, which deals with urgent cases of nuisance or apprehended danger, or when we start discussing right from section 145 up to section 148 of this chapter, we come to know disputes as to immovable property. Now, During course, when we shall be dealing with these chapters, this is just the introduction. And why it is introduction? This is the time for me to remind you that as we have started dealing with the provisions of the Criminal Procedure Code, during course of time it is necessary for you to do some homework in order to understand the provisions of the Criminal Procedure Code with which we are dealing. Or once I deal with the provisions, or I give you general idea as to the provisions or as far as the chapter is concerned, if you read in detail, it may not be possible for me. I shall be trying my best to cover all the provisions, but during course of time, as it is necessary for us to go through each all the provisions, it may not be possible. But for you, you must, whichever may be the textbook that you shall be reading, but as I have told you in the past, Bare Act is a must. Now, as we have dealt with the provisions, if you remember, during last part as far as search warrants are concerned, where we dealt with section 93, section 94, section 95, we read with section 96, 97 and 98. I hope all of you have not forgotten the importance of the second schedule of the Criminal Procedure Code, and you must have read form number 10 and form number 11 from the point for the purpose of understanding provisions regarding search warrant. Similarly, this is the reason why I am repeating this. Maybe sort of a repetition, but this is must. This is the practice that is required to be followed on the part of each who has to understand the provisions of the Criminal Procedure Code. So this is the chapter where we shall be dealing with preventive measures, whereas when we shall deal right from section 125 up to section 128 of the Criminal Procedure Code, dealing with maintenance of wives, parents and children. Order for maintenance of wives, parents and children. During course of time, when we will work out details as far as this chapter is concerned, you will come to know where this is a substantive provision. Why it is substantive provision? It defines what is duty of the husband, what is the right of the wife, and if the husband fails in his duty, how his liability starts. As we have dealt, these provisions regarding substantive law is that law which defines right, duties and liabilities of an individual. This is the provision with which we shall be dealing during course of time. So this is a substantive provision right from section 125 up to section 128. We start with the Criminal Procedure Code in the real sense of the term, with which we shall be dealing right from section 154 onwards of the Criminal Procedure Code. The offence has taken place. How one can set criminal law into motion? Who can set criminal law into motion? What is the procedure that is required to be followed? What do you mean by investigation? What do you mean by inquiry? What do you mean by trial? What do you mean by revision? What do you mean by appeal? All provisions with which we shall be dealing when we start right from section 154 of the Criminal Procedure Code. So that is, the procedure with which we shall be dealing. But let us, come back and finish up with those provisions to which I made mention in the past. Chapter 8, dealing with security for keeping the peace and good behavior. Now, immediately before you start reading any one of the sections, my sincere advice to you would be, please do read form number 12 to form number 17 as far as second schedule of the Criminal Procedure Code is concerned, in order to understand the chapter with which we are dealing, namely security for keeping the peace and for good behavior. Now, once you start dealing with this particular provision, we will understand that there are two sections, namely section 106 and 107. They deal with security for keeping the peace, whereas section 108, 109 and 110 are the sections which deal with security for keeping or security for good behavior. So this is right in the beginning classification. As I have told you in the past, when chapter consists of, try to
read the sections in such a manner so that it is possible for you to club the sections from the point of view of understanding the importance of the chapter. So as you read the heading of the chapter, security for keeping the peace and good behavior, immediately it must click you that there are two sections, 106 which deals with security for keeping the peace on conviction, and section 107 security for keeping the peace in other cases. Whereas section 108 deals with security for good behavior from a person disseminating seditious matter, whereas section 109 is meant for the cases where the security for good behavior is required to be taken from a suspected person. And then section 110 security for good behavior from habitual offender. The reason why I have made mention of all these sections may not be possible for me to work out all the details, but in order to understand and master the provisions of the Criminal Procedure Code, each one of you must read these sections in detail to understand the importance of the same. Habitual offender enumerated. Who is habitual offender? For that, as you read section 110, you will come to know who is what is known as an habitual offender. But for that, it is must for you yourself to read section 110. Person in a case where he is a suspected person. Now, who is suspected person? If you read section 109, that tells you a person who has taken precautions to conceal his presence with a view to commit a cognizable offense. And then when a security for good behavior is taken from a person who is going to disseminate or disseminating seditious matter. Section doesn't confine only to sedition as it is defined by section 124A, but as you read the section 108, you will come to know the importance of the section. So this is part 1 that you have to understand. Now there is also again classification. Section 106 deals with the cases where the person is asked to give security for keeping the peace on conviction. So this provision will come into operation only when there is order of conviction by the court of law, maybe by the court of magistrate or maybe by the court of session. Now, can every person who is convicted can be asked to execute a bond for keeping the peace when he will come out of the jail? The answer is in the negative, and that is made very clear when you read section 106 subclause 2, which has enumerated 4 categories of the offenses. So if the person is accused of and convicted of any one of the 4 categories of the offenses which are laid down as per subclause 2 of section 106, such person is required to execute a bond for keeping the peace. Now, no other procedure is required. Such a person is asked to execute a bond. Now, if the person is asked to execute a bond by a lower court and the matter goes in appeal, and I hope you remember the provisions regarding appeal. In order to know the provisions regarding appeal, with which we shall be dealing in detail during course of our lecture, where you have to read right from section 372 up to 394, or the provisions when the court is dealing as far as revision is concerned, and for the purpose of understanding we will refer to revision by reading right from section 397 up to 405 of the Criminal Procedure Code. So when the matter, a person is convicted by a lower court and matter goes to the higher court in appeal, and higher court sets aside the order of conviction and that is converted that of an acquittal, the bond becomes void. Similarly, this power of asking a person to execute a bond for keeping the peace can be by a trial court, it can be by a court exercising appellate jurisdiction, or it can be by a court exercising revisional powers as far as criminal procedure code is concerned. So, as you start reading section 106, you come to know security for keeping the peace on conviction, where you read 106 and you understand the same. Now, the period for which the person is required to execute a bond, maybe for keeping the peace or for good behavior, is very important. What is the duration of the bond? Whether the bond is with surety or bond is without surety. Each section makes it very clear. As far as section 106 is concerned, that tells us the maximum period for which a person can be asked to execute a bond for keeping the peace as per section 106 is not more than 3 years. Maximum duration of the bond is 6 years. Maximum duration of the bond is 3 years. When you read section 110, you will come to know the maximum duration of the bond is 3 years, not more than 3 years, but the maximum period is 3 years for which a person, habitual offender, can be asked to execute a bond. And then if you read section 107, if you read section 108, if you read section 109, you will come to know the maximum duration for which a person is asked to execute a bond is 1 year. Now, barring only one section, namely section 110, which says the person has to execute a bond with surety and with surety only. In rest of the cases, bond may be with surety or without surety as per the discretion which vests in a court of law. So, this has to be understood from the point, the period for which a person can be asked to execute a bond, whether it is with surety or without surety accordingly, and then details as far as section 108, 109, 110, with which we shall be dealing, no doubt about it, or we will work out the details of the section to a certain extent, but this is the time for me to tell you that it is must for you, before you start learning, you first of all must read the section so that it becomes very easy for you to understand the provisions with which we are dealing. Now, leave apart section 106, but this is the time for me to draw your attention to further part. When a person is asked to execute a bond for keeping the peace or good behavior as per section 107 or 108 or 109 or 110, then it is the duty of the court to make an order, and that too in writing, which is sort of a show cause notice as laid down by section 111. And then once you read this section 111, this is an order which is passed by the court of law, and which is the court. Now here, as per section 107 up to 110, the court that will come into play, or the court will that come into picture, is the court of executive magistrate. And what he is supposed to do? Executive magistrate, when he has passed an order in writing as per section 111, he will have to conduct an inquiry as per section 116 of the same chapter. So this is an inquiry. Why it is an inquiry? The object of recording of the evidence is not to find out guilt or innocence, but to tell a person or to ask a person to execute a bond or not to execute a bond. Hence, this is what is known as an inquiry. I hope during course of first introduction, I made it very clear as to what is the distinction between investigation, inquiry and trial. So court will conduct an inquiry as far as section 116 of the chapter is concerned. And what is the result of the inquiry? The result of the inquiry is, as per section 170, asking a person to execute a bond as per the order that is passed by the court of law as far as section 111 is concerned, or the person is set free, he is released, he is discharged as far as section 118 is concerned. Now, the power that vests in a court of law is to reject surety, cancel surety, asking a person to execute a fresh surety. What do you mean by breach of bond? Or when the person can be asked to undergo imprisonment in default when there is a breach of the bond, are the rest of the provisions which are dealt as far as this chapter is concerned. But then this is a time for me to draw your attention that as you start learning the provisions as far as security for keeping the peace and good behavior is concerned, it is a must that first of all it is necessary for you to go right from section 106 up to 124 so that it becomes possible for you to understand the provisions of the criminal procedure code with which we are dealing as far as this chapter is concerned. Now, in the next part, we shall start discussing in detail the importance as far as this section is concerned in detail.